Welcome to the channel viewers. Dr. JWA, theologist. Tickle versus Giggle, behavioural-constitutional analysis. When the law changed before the country realised. The train doors close at Central Station. Fluorescent light reflects across tired faces staring silently into phones while government announcements echo mechanically through the carriage. Nobody appears panicked. Nobody appears revolutionary. The country still outwardly functions. But constitutional destabilisation rarely begins through visible collapse. It usually begins through unnoticed redefinition. Long before the Tickle versus Giggle verdict reached public attention, the legal architecture underneath Australia had already shifted, quietly, procedurally, administratively. In 2013, amendments to the Sex Discrimination Act expanded protected identity classifications surrounding gender identity. At the time, most Australians never fully understood the constitutional implications buried inside the legislative language. The country largely interpreted the amendments as administrative fairness, modern inclusion, and compassionate institutional adjustment. But constitutional systems are not governed merely by emotional intention. They are governed by definitional consequence, and that distinction matters because once foundational legal categories begin expanding beyond their inherited constitutional boundaries, future institutional interpretation also expands with them. And years later, the Tickle versus Giggle verdict emerged downstream from those earlier definitional alterations already embedded inside the legal structure itself. The hardware store viewed idols beneath overcast skies, while a tradie scrolls headlines during his lunch break. He does not fully understand the legal reasoning, but he feels something psychologically heavy underneath it. The words still appear familiar: woman, sex, protection, discrimination, rights. Yet the operational meanings underneath those words no longer fully align with the ordinary Australians historically assumed what they meant. That psychological separation becomes socially destabilizing because constitutional trust partly depends on citizens believing, language remains anchored, definitions remain bounded, and institutions remain constrained by limits outside themselves. But modern institutional systems increasingly operate through adaptive managerial expansion instead. Definitions slowly stretch beneath procedural reinterpretation. Language becomes administratively elastic, and the population adapts psychologically before it consciously recognizes what changed. Inside office corridors, university policies, HR departments, digital platforms and bureaucratic frameworks, Australians increasingly learn caution around terminology, reputational self-monitoring, conversational restraint, and adaptive silence beneath institutional uncertainty. Not because tanks entered the streets, but because semantic instability quietly entered ordinary life. The constitutional danger is not merely disagreement. Constitutional systems can survive disagreement. The deeper danger emerges when foundational categories themselves become permanently negotiable beneath institutional authority, increasingly uncertain of limits above itself. And that is where the Tickle versus Giggle case becomes larger than transgender politics alone. It becomes a behavioural constitutional exposure event, a revelation that Australia may no longer fully agree upon what sex legally means, what woman constitutionally means, where institutional authority stops, or whether inherited civilisational definitions still possess restraining force above administrative reinterpretation. The train continues moving through the tunnel. Passengers remain silent beneath the fluorescent hum. And outside the carriage window, the city still looks stable. But beneath the procedural continuity, another reality slowly surfaces. The legal shift occurred years earlier. The verdict merely revealed the consequence that had already been silently approaching through the constitutional architecture itself. And once institutional authority begins redefining foundational categories, faster than civilization consensus can metabolize them, the resulting instability no longer remains merely political. It becomes constitutional, psychological, civilizational, and eventually spiritual in character. Because every constitutional order ultimately reveals whether it still believes there are limits above human authority it is not morally permitted to cross.